This year is a financial struggle for most consumers, with soaring food prices and interest rates, as well as a weakened rand. 2 years ago, South Africans were named the biggest borrowers in the world by the World Bank, and the problem persists to this day. This has led to many consumers becoming victims of loan sharks and predatory lenders as they try to make ends meet. Consumers take out loans with high repayments that aren't suited to their circumstances. Credit abuses and frailties in the legislative framework, compounded by financial illiteracy, leave borrowers vulnerable to manipulation by lenders. This is according to an SA Law Journal article by Dr Stephan van der Merwe, a senior attorney at the Stellenbosch University of Law. But why are consumers lacking sufficient legal protection against lending and debt collection abuses? To answer that question and more, we welcome Dr. van der Merwe to the show this morning. It's so good to have you. Thanks very, very much for your time.
Good morning, Leanne. Thank you for having me.
And it's such an important conversation at this point. And I suppose maybe I need to just kick off by asking, does South Africa have a debt crisis?
Leanne, you're completely correct. And according to the research findings, which you've also mentioned, released amongst others by the World Bank, South Africans unfortunately do have the reputation of being some of the most indebted people in the world. It's estimated, for example, that about 73% of all disposable household income is expended on debt, and that our unsecured store and credit card debt amounted to about approximately 18 billion in 2019. And so while credit facilities can be a good thing, obviously, and a lot of people would attest to having credit available and making a huge difference in their lives, it becomes a problem when there's irresponsible and reckless credit that's granted to people who simply can't afford it and then get over indebted. And so what the research also showed is during May 2019, for example, alone, during that month, almost 19,000 judgments for debt with a total value of about 342 million rand were granted by our courts. And in that month, also about 47,000 summonses were issued for debt, again, just in 1 month. So I think one would be very much merited in arguing that there is, in fact, a debt crisis here in South Africa.
I mean, if South African consumers are in such a vulnerable position, what can and should be done to assist them?
Well, you see, the reality of is that yes, they are vulnerable, and you've mentioned some of the reasons, being things like the legislation being quite dense and difficult to understand. We must look at the history of South Africa in terms of how we got to this point where during the apartheid years, obviously a lot of people were denied credit. When that system ended, the floodgates opened. A lot of people were then provided with credit without being empowered and educated how to actually deal with that credit. And so in our contemporary environment as well, we have huge levels of poverty, so people need the money quite desperately. We have huge levels of illiteracy. And so people simply aren't, lenders generally aren't well armed, and there's an imbalanced relationship between them and unscrupulous creditors who do this for a living on a daily basis. And so what we really need is a few things. We need better debt education. And so we need programs to inform people how to responsibly lend. We need an improved regulatory environment. So we need people to assist those debtors. We need them to have access to affordable legal aid to assist them with these complicated situations. And then we need legislation which is a lot more user-friendly. We have a fantastic constitution which assists, but then we have legislation like the National Credit Act, which is actually the piece of legislation that more than anything should be assisting our consumers. But it's a notoriously poorly drafted piece of legislation, and millions of rands has been spent to try and figure this out. And so we need improved legislation. We also need the courts then to assist our debtors and consumers against these kind of situations.
I mean, you've put it so eloquently about the Constitution and how it provides for equal access to the courts where debt is concerned. But this is effectively denied to poor South Africans, and that is the real problem, particularly where smaller debts are involved. Are our courts missing an opportunity to actually strengthen the rights of borrowers against unscrupulous practices of lenders?
Yeah, we found that what happens is that often an unscrupulous lender, what they would do is they would target impoverished lenders, people who would really take out very small loans. So let's say an amount of 500 Rand or 1,000 Rand. And then during the course of the collection of that debt, the creditor would collect 10 times that amount. So we have on court records, and we have at the University of Stellenbosch's Law Clinic as well, we have records of these type of transactions where a person would be in debt for 500 Rand, and then 5,000, 6,000 Rand would be collected against them over the course of a period of time. And so what we need is, as I say, is for legal aid to be available and for the courts to step up and to say, but we can't have our debtors be exploited to this extent where there's such an over collection that they're completely fleeced.
Is the problem dire enough to warrant judicial intervention at this point and effective access to courts to assist the vulnerable debtors?
I think personally it's a hugely important issue. If you go back 10 years and you look at what happened in Marikana, a huge contributing factor to Marikana was the fact that those miners who worked at the mines did not receive, at the end of the day, when they received their salary, they didn't receive enough money to be able to sustain themselves. And that was because of unscrupulous creditors who got their claws into that little mining town and completely over-collected. And so to answer your question, yes, it's really an important issue, and it's something that we need to address in South African society. Also, if we are serious about social economic rights, or if we're serious about social justice and really just constitutional values.
Yeah. One of the key reforms that was introduced in the post-apartheid era was the overturning of jail time for debtors, previously allowed under the Magistrates Court Act. So in 1999, the Microfinance Regulatory Council was created to actually encourage increased access to credit for all South Africans and to combat abuses. So the MFRC was later incorporated under the National Credit Regulator when the National Credit Act came into force in 2007. I know you outline this a lot in your article, so I'm pretty much so just summarizing what it is you were saying. And also followed this was the Consumer Protection Act, which is also intended to give consumers stronger legal rights. But I mean, despite all of these advances, the abuse of borrowers continues. So the question is, whose responsibility to realize the goals of transformative constitutionalism is it?
Yes, you've summarized it very well, Leanne, and the problem is, as I explained, is that you really have a very complicated situation. It's almost a perfect storm. We have on the one side debtors who are simply not on the level to understand what they're really getting into. And I mean, it's not because our debtors are stupid in general. It's because these are very complex situations. When you start talking about interest and interest on interest and deferred costs and all kinds of administrative costs and legal fees being added to arrears debt. Even those of us who are fortunate enough to have further education, we struggle to understand these types of matters unless you have a financial background. And so really it's a question of that the legislature, in my opinion, should come to the table. So we should be looking at the National Credit Act. We should be looking in terms of how that act can be made more consumer friendly, because as I mentioned earlier, it's very dense. It's very, very difficult to understand. Millions of rands have been spent by attorneys at courts trying to get clarity on important issues like this matter of when and how do we stop over collecting of small debts. And so legislature and then the courts need to come and assist our consumers and debtors as well.
I mean, I'm reading what you say here, just to put it in numbers so perhaps people can actually understand that. You give one example of May 2019. Courts granted nearly 19,000 judgments for debt worth 342.1 million Rand. And the same month, we saw 47,360 summonses being issued for debt recovery. That's 1 month. I mean, it's unsustainable in courts.
Yeah, no, it's huge, and takes, as a result of what you've just mentioned, it also means that our courts are so busy dealing with these types of matters that obviously it doesn't free up resources for looking at different kind of things. So, yes, the entire system needs to be re-looked at.
Unjust debt collection practices. I mean, how do they infringe on consumers' rights of access to courts and the livelihood and dignity of low-income earners in a nutshell?
Well, yeah, it's the nutshell is difficult. Yeah, I would say that it comes down to, as we mentioned, the fact that, and often we found in practice that you have a debtor who has incurred a loan that was given to them on a reckless basis. They simply can't repay. And what you get with the really unscrupulous creditors as well is that they would make it impossible for the debtor to repay the loan. So they would grant a loan which they know cannot really be afforded, can't be repaid. And they also make the repayment impossible in so much as that they would have an arrangement, for argument's sake, for the money to be repaid at a certain office. And the office would be closed overnight, and the debtor has no details in terms of where payment should be made. So they can't repay, even if they want to, even if they could afford to do so. And then the next thing that happens is that typically their salary or wages get garnished, or there's an EFT debit order against their bank account. And so the money just starts to be deducted. And then if the creditor does not, from their own initiative, approach the courts or stops these payments, the monthly deductions, then it just rolls on forever. And you have then the situation, as we mentioned, that, and this is undisputed, that you have cases where 10 times, 12 times, the initial debt has been collected. And if you contact that creditor, they'll tell you, no, there's still some more money owing. So there's a financialization of these very small debts that we need to look at.
Yeah, it's a major problem. I mean, when you look at it, and of course, you know, you buy the product, you can't afford it, and then of course there's all this interest, then you can't pay the interest on that, then you get handed over, and then once you're handed over, it grows every single day, the amount that you owe. I know I was trying to help somebody get out of debt at one stage, and every single time I'd phone, it had gone up by 100, 200, 300, 400 rand. I'm like, how is this possible that this is going on? And at the end of the day, you know, once you are blacklisted as an individual. And all of this because you've just been caught out by these unscrupulous lenders that are honestly trying to prey. And the bottom line is it's right in front of us, particularly when you look at retail. I mean, anything, you go into any retail store, they'll offer you some form of a scheme, knowing that you're just getting into trouble. I mean, this, in essence, shouldn't be allowed.
Yeah, I agree with you.
Yeah. If we look at, just finally as we start wrapping up, if we look into the imbalanced power dynamic, I mean the skewed power relationship between these parties, basically ensuring that the debtors are no match for creditors, and that's what I'm gathering from this. Is this why private law firms are unlikely to wade into the debtor protection?
Yeah, for several reasons. I mean, the one is that often your private law firms would work for some of the lenders, your bigger banks, for example. And so a private law firm would often be in a position where they would get into a conflict of interest if they were now to step up and represent these vulnerable debtors. And so for that reason, they won't get involved. And then obviously, typically your debtor who's trying to repay this small loan doesn't have the finances to pay a private attorney to get involved. And so you would have these debtors relying on legal aid, and good work has been done in that regard, but also obviously legal aid also has capacity issues. And so, yeah, that vulnerable relationship is problematic because it is simply a case of that. When you look at it, as I've mentioned, is that you have on the one side a creditor who is able to afford an army of attorneys and advocates on their side and to able to assist them to collect these loans. And on the other side, you have the debtor who has very little on their side in terms of assistance.
All right, Dr. Stephan van der Merwe, thank you very much for talking to us. Senior attorney at the Stellenbosch University Law Clinic, speaking about consumers lacking sufficient legal protection against lending and debt collection abuses. Take care out there when taking those loans. It's a very, very hard cycle and to get out of, so just be careful when you do take those loans.